When you have completed this unit, you will be able to identify the various types of estates, explain the difference between liens and other types of encumbrances, and explain the limitations on private property rights for the welfare of the public. Key point review. A freehold estate lasts for an indeterminable length of time. Fee simple is the highest estate recognized by law. Fee simple defeasible is an estate that is qualified because it is subject to the occurrence or non-occurrence of a specified event. A life estate is based on the lifetime of the life tenant or someone else per autre vie. An encumbrance is a claim, charge, or liability that attaches to real estate. A lien is a charge against property that provides security for a debt or obligation of the property owner. Covenants, conditions, and restrictions, often called CC and Rs, are private limitations on the use of land. An easement is a right to use the land of another. An easement is usually created by written agreement between the parties. An easement appurtenant is said to run with the land when title is transferred. The dominant tenement benefits from the easement, which runs over the servient tenement. An easement in gross is an individual or company interest in or right to use another's land. An easement by necessity arises when land has no access to a street or public way. An easement by prescription is acquired when a claimant has used another's land for the period required by law. The use must be continuous, non-exclusive, visible, open, and notorious. An easement is terminated when the need for it no longer exists, when the owner of either the dominant or servient tenement becomes the owner of both, when the owner of a dominant tenement releases the right of easement to the owner of the servient tenement, if the easement is abandoned, or by the non-use of a prescriptive easement. A license is a personal privilege to enter the land of another for a specific purpose. An encroachment occurs when all or part of a structure illegally intrudes on the land of another or beyond legal building lines. A lease pendens gives notice of litigation in progress that may affect title to property. Government powers can be recalled by using the acronym PEAT. Police power is the state's authority, passed down to counties and municipalities through enabling acts, to legislate to preserve order, protect the public health and safety, and promote the general welfare of citizens. Eminent domain is the government's right to acquire privately owned real estate for a public or economically beneficial use through condemnation. Taxation can include a charge on real estate to raise funds to meet public needs. Escheat occurs when the state takes control of property after the owner dies, leaving no will or lawful heirs. When a taking of property occurs, the Fifth Amendment to the U.S. Constitution requires that the owner be given just compensation. A property owner may claim compensation under inverse condemnation if an adjacent public land use diminishes the value of the owner's property, but the property has not been condemned for public use. Terms: police power, the right of any political body to enact laws and enforce them, for the order, safety, health, morals, and general welfare of the public. Eminent domain, the right of government to take private property for public use. Condemnation, taking private property for public use, with fair compensation to the owner, exercising the right of eminent domain. Escheat, the reversion of the state of property in event the owner thereof abandons it or dies, without leaving a will and has no distributes to whom the property may pass by lawful descent. What year did the Texas Supreme Court invalidate the state's right to retain all mineral rights to land? 1901. Allodial system, a system of land ownership in which land is held free and clear of any rent or service due to the government, commonly contrasted to the feudal system. Land is held under the allodial system in the United States. Fee simple, the highest interest in real estate recognized by the law. The holder is entitled to all rights to the property. Fee simple absolute, an estate in land that provides the owner with a complete set of legal rights, limited only by the powers of government. Fee simple defeasible, an estate which may be lost on the occurrence or non-occurrence of a specified event. Reversionary interest, interest in property in which a party's right to occupy land is subjected to a certain condition or conditions, and if unfulfilled or violated, all interests in the property revert to the original owner. Remainder interest, the remnant of an estate that has been conveyed to take effect and be enjoyed after the termination of a prior estate, such as when an owner conveys a life estate to one party and the remainder to another. Leasehold, rights the lessor grants to the lessee under the terms of a lease. Taxation, money raised to provide services for the common good of the community or country. Forms of ownership: the right of possession, the right of ownership, the right of enjoyment, the right of control, the right of exclusion, the right of disposition, the right of possession. A party is officially allowed to occupy and exercise direct control over a piece of real property. It is possible to possess a property and have the right of possession to that property, yet still not own that property. The right of ownership: a party that owns a property has the original bundle of rights for that property, from which other rights may have been removed. Holding the right of ownership means that a party is recognized as being allowed to hold the bundle of rights and organize the distribution of rights that the bundle contains. The right of enjoyment is the official recognition that a party can utilize a property in any legally appropriate way. The right of enjoyment also grants the right to collect the commercial profits that are generated by the property, such as rent or admission fees. The right of control is the official recognition that the holder of this right is allowed to determine how the property is used. It may be possible for the right of control to supersede the right of enjoyment. The right of exclusion: the holder of the right of exclusion has the recognized authority to determine who can and cannot cross into a piece of real estate. The right of disposition. Disposition refers to the act of giving away one or more individual property rights up to and including the entire bundle of rights. It is the right to rent, transfer, sell, or in some cases, abandon a property. Encumbrances: a claim against, a limitation on, or a liability against real property is called an encumbrance. Common encumbrances include easements, covenants, and liens, as well as encroachments. Profits: a specific kind of easement that not only allows access to another person's property, but also allows the removal of material resources contained in the property. Covenants: a real covenant, restrictive covenant, or simply covenant is a contractual agreement and is usually written into the document that grants the title. Encroachments: an encroachment occurs when a property owner builds something, intentionally or unintentionally, that sits, at least partially, on a neighboring property owner's land. Encroachments can occur accidentally if the division line between the properties is not clear or was improperly recorded. Easements: an easement is the right of one party to use the property of another party. A fee is paid to the property owner in return for the right of easement. An easement, therefore, does not dispossess the landowner. Easement appurtenant: an easement that attaches to a specific piece of land and benefits the easement owner. The land that benefits from the easement is termed the dominant estate, and the property that is burdened or affected by the easement is called the servient estate. Easement in gross allows rights to a servient estate without the easement being attached to or benefiting a particular piece of land. Since this kind of easement is not attached to a particular property, it remains with its holder. Affirmative easement allows the holder of the easement the right to use another person's property. Negative easement allows the holder to prevent the servient owner from performing an act on the servient land. Servient owner: the owner of the servient land. Remainderman: one entitled to receive a remainder interest in some estate sometime in the future. Life estate: a freehold estate in land that is limited in duration to the life of the owner or to the life or lives of some other designated person or persons. Life tenant: the holder of a life estate. Estate in reversion: property or estate ownership that reverts back to the grantor after a temporary ownership period. Estate in remainder: an estate which vests after the termination of the prior estate. Divisor: one who disposes of real property by will. Devise: one who inherits real estate under a will. Right-of-way grant: a right-of-way grant is a temporary easement that allows a utility access to a public property in order to install or maintain a piece of equipment like a water pipeline. Express easement: easements that are explicitly laid down in a contract, deed, or will. Easement by implication: an easement by implication occurs when there is a subdivision of a property and one of the smaller sections requires an easement. Easement by necessity: an easement by necessity is created solely by the necessity of the situation. The easement goes away, however, if and when the situation requiring the easement goes away. Easement by prescription: an easement that is established without the permission of a landowner or without necessity. The concept is that someone is using someone else's property as if they had an easement, but because it has been going on for a significant amount of time, and the servient property owner has done nothing about it, an easement is created. Terminated easement. Termination of an easement depends on the type of easement. Any easement can be terminated if the servient and dominant properties ever end up owned by the same party. Terminated easement can also be terminated by abandonment. To establish that abandonment has occurred, the owner of the easement must have intent to abandon the easement and demonstrate through actions and intention to terminate the easement. Terminated easement. An easement can be terminated if the servient property owner prevents the holder of the easement from accessing the easement for a specific period of time. An easement that is established without the permission of a landowner or the existence of a situation that requires an easement is easement by prescription. Liens. A legal claim made on another person's property for the purpose of securing or repaying a debt to the holder of the lien. Liens can be imposed by financial institutions for repayment of loans, or a lien can be imposed by the government for failure to pay property taxes. Liens usually carry with them the right of the holder of the lien to repossess and sell the property in order to pay off the debt. A lien is a form of encumbrance. An encumbrance is some form of legal obligation or burden that decreases the value of a property and can interfere with the transfer of a title. Liens can be separated into these three categories: consensual liens, statutory liens, and judgment liens. The importance of lien priority stems from the fact that foreclosure can sometimes cancel liens that are lower in priority. Consensual liens. A lien that is voluntarily agreed to, most often as a result of a loan or other credit extension. Mortgages, the most common kind of consensual liens that real estate agents deal with. There are two basic categories of consensual liens: purchase money security interest liens and non-purchase money security interest liens. Purchase money security interest involves a lender loaning money to a borrower for the purchase of a property that is used as security for the debt. First mortgages are a common type of purchase money mortgage. Non-purchase money security interest. Established when a borrower uses owned property as collateral for a loan. Second mortgages are common examples of this kind of lien. Statutory liens. A trustee may avoid statutory liens that first become effective on insolvency, are not perfected at commencement of the case, or are for rent. Judgment liens. Established as a result of a lawsuit judgment. The court-ordered lien is placed to guarantee the payment of the damages to an injured party. Judgment liens can also be imposed to secure payment of debts on things like credit cards and utility bills. Lien priority. The order in which lien holders are paid if property is sold to satisfy a debt. Voluntary lien. Any lien placed on property with consent of or as a result of the voluntary act of the owner. Involuntary lien. A lien imposed against property without consent of an owner, such as taxes, special assessments, federal income tax liens, etc. General lien. A lien that attaches to all property owned by an individual, both real and personal. Specific lien. A lien that attaches to one specific property only. Priority of lien. The order in which liens are given legal precedence or preference. Subordination agreement. An agreement by the holder of an encumbrance against real property to permit that claim to take an inferior position to other encumbrances against the property. If a property has a lien for $50,000, $100,000, and $250,000, and the owner refuses to pay one of the liens, then the lien holder can, in many circumstances, foreclose on the property. An example of lien priority. First in time, first in right means that older loans must be paid off before younger loans.